present and future. On behalf of the conveners, I'd like to thank you all for attending this evening's presentation, and similarly, no doubt, I can extend your gratitude to those that are convening this conference, and in particular, that's the Constitutional Centre, the Electoral Regulation Research Network, and also the Australian Association of Constitutional Law. I've been asked to let you all know that at the back of the room after the presentation this evening, there are some membership forms if anyone is looking to join those particular organisations or to become included on mailing lists. But of course, we are here tonight to discuss the recent decision of the High Court in Unions New South Wales and New South Wales. And we're very lucky to have two presenters here to guide us through that decision, including both some doctrinal aspects of the case and also some broader background and implications arising from the decision. Our first speaker this evening will be Dr. Martin Drum. Dr. Drum is an Associate Professor in Politics and International Relations at the University of Notre Dame, Australia in Fremantle. His primary research areas are elections, public policy and Australian politics. Martin is passionate about getting more people to participate in the political process and ensuring transparency, integrity and fairness in our political institutions. If you could join me in welcoming Martin.
Thank you, Kobe, and like Kobe, I'd like to thank all of the organisers for this event this evening. With regard to my presentation and Murray's, I'm going to focus more on the background and context and talk about the broader political donations framework. I'm going to touch briefly on the West Australian framework as well, and Murray will go into more detail about the case in question. So with that in mind, I thought I'd start by talking about how campaign finance regulation comes about. It doesn't emerge out of thin air. We know that regulation is usually a responsive action to a series of events that have taken place, usually within that jurisdiction. And in the case of New South Wales, which has, as I'll come to, one of the tightest political finance regulations in the country, they've had their fair share of scandals. And this has played a big role. Those two gentlemen on the right were frequent visitors to the Independent Commission Against Corruption in New South Wales, and they've both spent time behind bars. Although I should say, the gentleman on the right, Ian McDonald, was released and as a result of an appeal. But those events were very, very public and widely discussed across New South Wales politics, and they were the real drivers behind the legislation in 2011 in New South Wales that imposed caps on donations and caps on expenditure with regard to political finance. There were successive problems under the Liberal government that succeeded that Labor government, including donations in brown paper bags and a range of banned property developer donations being accepted. So it is an issue that stayed in the headlines, and that's still an important context for the 2018 legislation that we're talking about as well. So you need an immediate political justification. The third tranche there that I've mentioned is recent reform around the banning of foreign donations, and again it's linked to issues around Senator Sam Dastyari amongst others, but in particular he was in the spotlight due to his association with Chinese donors. So let's move on a little bit more to look at the New South Wales political donation framework. New South Wales has the lowest disclosure thresholds in the country, $1,000. Sounds good to me, I'll come to that. I think that other jurisdictions could follow suit. Donations are capped, so there are maximum amounts of donations that an individual or a group can make. Expenditure is capped, and that's the issue that we're going to be exploring a bit further this evening, including third parties. Donor and third-party returns are required, so not only are political party returns required, but donors and third-party campaigners also put in their own returns. So there's extra added transparency there. There are restrictions on foreign donations, and the reporting on expenditures is a half-yearly cycle, which is more frequent than some of the other jurisdictions, including Western Australia. So you can see how we've got a much tighter regulation. There's been a lot of money in New South Wales politics, and this is a response, a political response to that. Talking about the acts that we're talking about this evening, the original Campaign Finance Regulation Framework was passed in 1981, the Election Funding and Disclosures Amendment Act, with a further iteration in 2010, and that's that second tranche that I'm going to go into a little bit more detail before we talk about the Electoral Funding Act 2018, which is the act that was challenged in the High Court more recently, and that Murray will talk about. Now, if we go to Union New South Wales, the Parliament in 2018 passed the Electoral Funding Act, and in most cases the existing caps on political expenditure and political donations were retained. I'm going to flick through to that before coming back to, there it is, the changes. This is the existing caps, and you'll see if you look carefully that they're very much scaffolded. So those large political parties that are standing in every seat in both the Assembly and the Council have much bigger caps than smaller parties that are only contesting the Council. You have smaller caps still for independent candidates. You have specific caps for by-elections, and you have specific caps for third-party campaigners. When this legislation was drawn up, there was a long consultation process. There was a range of considerations taken into account, and the amounts that were put together were considered relative to one another. The point being that political parties who are campaigning across all 93 seats in the Assembly, plus the 21 vacant seats in the Council, are going to be spending a lot more than, say, a single-issue campaigner campaigning in inner-city Sydney, for example, or a smaller party that's only campaigning in the Council. That relativity is important when we come to the case in question, because if you're going to suddenly arbitrarily change one of those amounts significantly, then perhaps you're putting that amount out of proportion with all of the other ones. And if you do your sums, there's $9.3 million available to the major parties to spend, was available to the major parties to spend in the 2019 election that we had recently. Hope that all makes sense. So I'll go back to the Union's New South Wales background. Basically, there were two major changes in the 2018 legislation. It's a reduction in the amount that third-party campaigners, including unions, and I say that because the plaintiffs are unions, are permitted to spend on election campaigning. There's also a second prohibition that stops collusion, that seeks to prevent multiple actors in siphoning money around to get around those caps. I think Murray's going to be focusing predominantly on the first, but the second one was a significant change as well. This is the objects of the Act, and I included these for two reasons. One, the High Court refers specifically to the objects of the Act in the judgment, and secondly, it gives us a chance to think about why people go down this path of tightening regulation around political donations. They're talking about fairness and transparency. They're talking about public awareness. That's probably a bit thin unless there's a scandal. I don't think passing an act in itself probably achieves that. Preventing corruption and undue influence at all levels of government. Provide for the effective administration of public funding of elections, and promoting compliance by a whole range of actors with the overall scheme. The High Court, and I'm infringing a little bit on Murray's territory here, have not taken issue with the purpose of the Act. All right? So they're talking about the way the legislation was framed and the way the government went about legislating. So the objects of the Act are, for the most part, considered legitimate object, legitimate purpose. providing, if you go into the actual speeches that are taken around the legislation, you'll see further rationales that are explored. And one of the reasons why third-party campaign finance was being looked at was because of what was happening over in the States, where you have political action committees which spend an enormous amount of money. This is just an example of the biggest 5 PACs ahead of the 2016 federal presidential election. And it might be a little bit blurry there, but Hillary Clinton's Priorities USA Action spent bit over $132 million. That's some serious money. The Jeb Bush campaign, their largest PAC, spent more than $86 million. That's a lot of money down the gurgler. They still dominated PAC funding even after he dropped out of the race. We have one supporting Rubio, and the amounts of PACs supporting Trump were not particularly high in the 2016 election, interestingly. So there's the broader arguments around reforming political donations talk about a level playing field. They talk about wealth not being an obstacle, or lack of wealth not being an obstacle, preventing a political arms race, and the drowning out of other voices. And I think Murray will touch on that last part as well. So the particular contentious provisions of the Act, 2910 reduces the cap for electoral expenditure to $500,000. Now, if we go back, you'll see that the current cap is double that, approximately. Third-party campaigners is the second one on that list. So it's just a tick over $1 million, and it's down to $500,000. So when you're halving one particular cap like that and you're not adjusting the other caps, how does that impact on the relative capacity of third-party campaigners to campaign in that election? The other sections were sections 35, 1 and 2. 5 of the 6 plaintiffs were registered third-party campaigners. So they're very much affected. They have relevance to the case. And 3 of these 5 would not have been permitted to spend the same amount of money they spent at the last election in 2015 were this Act to be passed. So they'd have to reduce their expenditure from the previous election. As long as that's not me, I'm happy. Usually is. What are some of the implications of the case? I'm not going to go into enormous detail here because Murray will look more closely at the case. But capping campaign expenditure, as exists in the current New South Wales legislation, is deemed a legitimate practice for all of the purposes that we looked at in the previous slides. So it is seen as legitimate to create a level playing field, to restrict to some degree the capacity of individual campaigners relative to others. What we will see, though, is that the extent to which you cap campaign expenditure will be the issue. And in particular, how you go about justifying such a change in the cap to expenditure. Because as the court made clear, you are inherently limiting freedom of political communication. This is true of both capping expenditure and also of capping donations. To some degree, you're limiting freedom of political communication. To what degree is that a legitimate limitation, though? And I don't think it's the last thing that we're going to see around that. There's some broader notes to make that I think are really important around this. So firstly, political communication is important. It's important for the voters to understand who they're voting for. People who do have a right to put their message out into the public domain. So even if we find some of those ads excruciatingly nauseous at one time or another, nevertheless, we can't deny political parties do have that right to communicate with us. We also, though, have a right to limit or to understand more effectively where that money is coming from and where it's being expended. One of the emerging issues, and this was examined recently in a parliamentary inquiry, was trying to understand the reach and the nature of third-party campaigners in our electoral system. We have fairly clear and strict guidelines that political parties are expected to meet when it comes to their own affairs as registered entities. A lot of those transparency measures don't apply to third-party campaigners. So where do they fit into the broader campaign finance regime? At the moment, it's not very clear. The government did propose to add to levels of disclosure for third-party campaigners, but they ran into significant headwinds. One of the problems was that many organisations that might campaign politically are also involved in a whole range of other operations. So NGOs might campaign politically on a range of issues, but they're also involved in service delivery. They're also involved in a whole range of community activities locally. So trying to understand where a donation that you might make to one of those organisations goes, whether it goes to helping out local needy people or whether it goes to campaigning for a political solution, is not very easy. And one of the criticisms of trying to force more disclosure on third-party campaigners was that you would be adding to the bureaucratic nightmare that many NGOs face. So it is a very complex area, and it's a largely unresolved area. To some degree, we certainly do know that third-party campaigners can make an influence in elections, and we do have a right to know a little bit more about where the money's coming from and where it's going to in terms of expenditure. So I like to put that out there as a fairly unresolved issue that we're going to see come up again for sure. I said that I'd mentioned WA's election funding framework. If we regard New South Wales as one of the most tightly regulated jurisdictions in Australia, Western Australia is very much at the other end. We are pretty lax when it comes to regulation of donations and expenditure. Our disclosure thresholds are higher than in most other states and territories. $2,500 is the disclosure threshold. So if you donate less than that, then it won't be disclosed. Political parties receive less, $1.91 per vote than in Western Australia than they do in other jurisdictions. And party returns are still annual. If you took a particular interest in WA politics, you might have seen disclosure come out this week about donations in the last financial year. Now, the last financial year is the 30th of June 2017 to the 1st of July 2017 to the 30th of June 2018. So some donations that were made in July 2017 are just being made public now. So there's a range of reasons why the delay that we have in annual returns is unacceptable. Election-related gifts are not declared for 15 weeks in Western Australia. We don't have donation caps. We don't have expenditure caps. There aren't restrictions on foreign donations. This is probably a chart that's impossible for you to read, that outlines where we sit in terms of our comparative campaign finance regime and other states and territories and nationally. And basically it demonstrates what I've been trying to say. Much lower, much higher disclosure thresholds, lot less. The line of X's there refers to the lack of caps and also refers to lack of other transparency measures that exist in other jurisdictions. So we really do have some way to go. The particular things that I would say that we need to work on in political donations in the West Australian context are timely disclosure of donations and a threshold that really does capture any donation that's likely to influence a political outcome. So that's where I'm going to leave it for now, and I'm happy to hand over.
Thank you, Martin. Murray Wesson is a senior lecturer at the Law School, University of Western Australia. He has previously lectured at the University of Leeds, the Central European University, and the University of KwaZulu-Natal. He teaches and researches in the areas of constitutional law, human rights law and legal theory. If you could join me in welcoming Murray.
Okay, thank you for the introduction. Also thank you to Martin for that fascinating talk, which I think provides some very helpful context for the more doctrinal analysis that I will offer of the High Court's decision in Unions New South Wales number 2. And of course, also thank you to everyone who's been involved in organising the event this evening. So Martin has already touched on the sort of background to Unions New South Wales number 2. And as he has already pointed out to you, a key aspect of that case was that the Electoral Funding Act of New South Wales reduced the amount that third-party campaigners are permitted to expend during an election campaign. There was also a provision that, as Martin noted, dealt with collusion between third-party campaigners, but only one member of the court got to that provision, so I'm not going to be discussing it this evening. 6 members of the court instead found that the legislation was invalid in respect of this provision. Now, what prompted this change? The New South Wales government had asked an expert panel to look at the issue of third-party electoral expenditure, and they had recommended this reduction in 2014, but that recommendation was based upon expenditure in the previous 2011 election. And the expert panel specifically noted that the new cap, if adopted, should be reviewed after the 2015 election. And as it happens, some of the third-party campaigners in that election, trade unions, did spend more than the proposed cap. In addition to that, the Joint Standing Committee on Electoral Matters in New South Wales had cautioned that before decreasing the cap, the New South Wales government should consider if there was sufficient evidence that third-party campaigners could operate within the new limit. Now, as it happens, the New South Wales government went ahead and introduced the bill that amended the legislation without undertaking this analysis and without noting the caveats and qualifications that had come from the expert panel report and the Joint Standing Committee on Electoral Matters. And the result of that is that the state of New South Wales in this case had a very flimsy, perhaps even non-existent justification for the new cap, because to the extent that they could provide a justification, it had to do with the expert panel report. But in lowering the cap, they'd ignored some crucial qualifications that could be found in that report, as well as qualifications and caveats that had emanated from the Joint Standing Committee. So in one sense, this was not a terribly difficult case, I think, for the High Court to decide, given the very limited justification that had been provided for this reduced cap. And in that light, it's perhaps unsurprising that the High Court unanimously found that the reduction in the cap breached the implied freedom of political communication. Notwithstanding that, though, I find it surprising that this case produced 5 separate judgments. The current High Court, under the leadership of Chief Justice Kiefel, has placed a premium on limiting the number of judgments, on working collaboratively. And so, given that, in one sense, it wasn't a difficult case, as well as that it was a unanimous outcome, it's surprising that there are, I think, 5 separate judgments. And to some extent, I think, that points to the fact that there's currently controversy about the implied freedom of political communication and how cases involving the implied freedom of political communication should be determined. And what I want to do this evening is to guide you through some of those controversies. It's also surprising, I think, that even though there are 5 separate judgments, many of the judgments actually skirt certain of these controversies and don't really resolve them, which is something else that I'd like to point to. So It's an interesting judgment because on the one hand, we actually do have a very clear message that where states enact legislation that bears upon electoral expenditure law, and that legislation might distort the democratic process, the High Court will look very closely at the legislation and may find that it's invalid. But on the other hand, even though there's that very clear message in one sense, the case doesn't bring us a lot of clarity, I think, about the implied freedom of political communication, which is why I titled my presentation this evening, Unresolved Issues for the Implied Freedom. Another important part of the context for this decision is the previous decision, which Martin also alluded to, of the High Court in Unions New South Wales No. 1. And in this case, the New South Wales legislature had banned political donations from organisations or persons who are not enrolled voters, and as well as that, had aggregated the electoral expenditure of parties and affiliated bodies for the purpose of expenditure caps. Now that might sound simply technical, but the way the legislation was drafted meant that it really specifically applied to the Labour Party, the Australian Labour Party in New South Wales, and its relationship with the trade unions. And so Professor Anne Toomey, for example, has described this legislation as having a flagrantly political or partisan purpose of disadvantaging the Australian Labour Party in elections in New South Wales. And I don't really think you can read Unions New South Wales No. 2 without being aware of that background. Now, the way the High Court dealt with this, when they were presented with this legislation that had this rather flagrantly partisan nature, is that when it came to assessing what the object or purpose of the legislation was, they simply said they couldn't work it out, which I think is a rather polite, or was a rather polite resolution of the issue. So in respect of both of those provisions that were an issue in Unions No. 1, the majority in that case said it's not possible to attribute a purpose to these provisions, and so they failed at that early point in the analysis. Now, as has been mentioned already, this is a case about the implied freedom of political communication and whether this reduction in the cap on electoral expenditure by third-party campaigners breached the implied freedom. The way in which these issues are dealt with in Australian constitutional law is through the so-called Longy test. Now, I'm aware that there will be some members of the audience who are already intimately familiar with the Longy test, but I can see other members of the audience this evening who might be less familiar. So I'm going to just put the whole test up on the slide. And really it's a three-part test, in essence. Unfortunately, we'll see in a minute that the third step has a further 3 steps built into it, but we'll get to that. Let's just start with these 3 steps. And the first question is whether the law effectively burdens the freedom. If that question's answered in the affirmative, the court will then ask whether it has a legitimate purpose. And if that question's answered in the affirmative, the court will proceed to the question of proportionality, or whether the legislation is appropriate and adapted to the legitimate purpose of the legislation. Now, as a result of previous case law, there were a number of threshold issues that were simply not in contention in the Unions New South Wales No. 2 case. So, for instance, it was not in contention that state laws are subject to the implied freedom of political communication, even though it's an implication of the Commonwealth Constitution. It was also not in contention that this cap on electoral expenditure burdened the implied freedom of political communication, because it had previously been held in Unions New South Wales No. 1, and these points have been touched on in McCloy too, that any sort of cap on electoral expenditure will result in a restriction of the ability of persons or bodies to communicate to others. So obviously if a trade union, for example, has some kind of cap on its expenditure, that will restrict its ability to communicate. And so the result of that was, as a result of previous decisions, that the first question could be answered in the affirmative, and so the analysis moved to the second question about the purpose of the law and its legitimacy. Now, when it comes to determining what the purpose of a law is for the purposes of the Longy test, the High Court has on more than one occasion held that this is a process of ordinary statutory construction. So through ordinary techniques of statutory interpretation, the court will ascribe a purpose to the legislation. The slightly, or somewhat rather more, maybe dramatically more tricky issue is how to determine the legitimacy of the purpose once it's been ascribed to the statute. And there is discussion of this issue in comparative constitutional law, and at least one analysis from, for instance, Arian Barak, who's a writer whose work on proportionality has influenced the High Court quite profoundly, is that what you do is you consider what the purpose of the law is, and you then test it against the fundamental values of the Constitution. A difficulty, I think, in the Australian context for that analysis is that in the absence of a Bill of Rights, the Commonwealth Constitution is rather thinner on values than some other constitutions are. And so sometimes in assessing the legitimacy of the law, the court will be driven to substantively considering what democracy means in Australia, what representative and responsible government mean, given that the implied freedom is an implication of those provisions of the Constitution that establish representative and responsible government. Now, in this case, there was actually some controversy about how to understand the purpose of this legislation. So, two purposes were identified by the plaintiffs. The one purpose was to ensure a level playing field, and it was acknowledged that that would be a legitimate purpose, that third-party expenditure could be capped to ensure a level playing field. The other purpose that was identified was that the point of the legislation was to privilege the voices of political parties over those of third-party campaigners. So, in a sense, what this was, I think, alluding to was a possibly partisan motivation for this legislation, and in essence, that its point was simply to give, for instance, the trade unions affiliated with the Australian Labor Party less of a say in electoral campaigns. An interesting feature of this judgment, and I think it rather recalls Unions Number 1, is that 4 members of the court don't actually decide what the purpose of the law is. So Kiefel, Bell and Keane, for instance, in their joint judgment, simply go or proceed to step 3 of the Longy test on the assumption that the purpose of the law is to prevent the drowning out of voices. Likewise, Justice Gordon, in her judgment, said that it was possible to proceed to step 3 on the assumption that the purpose of the law was legitimate. And that's unusual, I think, and puzzling, but it is reminiscent of Unions New South Wales Number 1, and it perhaps speaks to the fact that it's rather difficult to ignore the possibility of some kind of partisan motivation for this change, given the outcome of Unions New South Wales Number 1, and given the fact that the ostensible justification was for the change in the expenditure cap was so flimsy. And it possibly also speaks to the fact that, on the one hand, the joint judgment and Justice Gordon were rather reluctant to delve into those issues, given that the motive for legislation is something different to its purpose. And I think it also speaks to the fact that at one level it was acknowledged that third-party expenditure can be curtailed, but really this was a question of proportionality. So, as you can see, some members of the court simply sought to avoid that rather vexed issue of what the purpose of the law was. Justice Nettle found more forthrightly that this was a law about preventing voices from being drowned out. However, I think the 2 most thought-provoking judgments in this case, as far as legislative purpose are concerned, are those of Justice Gageler and those of Justice Edelman. Now, I am pressed for time this evening. I only have 25 minutes, and so there's a limit to how long I can spend talking about particular aspects of this decision. And so I'm not going to spend a great deal of time analysing these judgments. I would just note, though, that what makes Justice Gageler's judgment interesting is that he really doesn't shy away from quite a substantive analysis of the role of political parties and the role of third-party campaigners. And what Justice Gageler says is that political parties, because they address a range of issues, whereas third-party campaigners may focus on one, political parties actually need to be able to raise more money. And so it's justifiable to place a cap upon third-party campaigners that treats them less favorably. I'm not going to say more about Justice Gageler's judgment, but it is striking for his sort of willingness to engage in that kind of substantive analysis. Justice Edelman, on the other hand, also in a very thought-provoking judgment, although I think quite a difficult one on this question of legitimate purpose, said that the purpose will be illegitimate where the purpose is to impair freedom of political communication. And what Justice Edelman then found was that the purpose of this cap was simply to impair the ability of third-party campaigners to make their voices heard during election campaigns. And so Justice Edelman, I think, by finding that the purpose was illegitimate, by resolving the case at this point, rather than proceeding to step 3, I suppose came closest to identifying some kind of partisan motivation for this legislation. My hesitation about Justice Edelman's judgment, though, is that I think if I understand his Honour's judgment correctly as saying that this is a sort of comprehensive test for identifying when the purpose of legislation is legitimate, I find that rather difficult to square with some earlier case law. I don't think this is the only circumstance where a legislative purpose will be illegitimate, but Justice Edelman's use of the word only does seem to imply that. But as I say, I'd rather not dwell too long on that point. Now, I mentioned already that step 3 of the Long-E test has a further 3 steps. And it's normally at this point that I start to apologize to students when I'm teaching this material. And I sort of say, sorry, this is so complicated. But of course, it's not my fault. So in that sense, the apology is irrational. But here we go. So when it comes to the third step, in other words, whether the legislation is appropriate and adapted to its purpose, in the earlier judgment of McCloy, I'm going to put the whole thing on the slide, but as you can see, it gets rather unwieldy. In the earlier judgment of McCloy, 4 judges in a joint judgment incorporated a proportionality test that has its origins in German constitutional law, but which is now applied in many other jurisdictions around the world, and which we can broadly refer to as structured proportionality. Now, there's a lot that can be said about this test, and it's generated a huge literature, but I'm going to just run through it rather briefly. In assessing whether the law is appropriate and adapted, the court will first ask whether it's suitable. Is there a rational connection between the purpose, the law, and the purpose of the provision? We'll secondly ask whether it's necessary, and there the issue is, well, is there an alternative measure which would impose less of a restriction on the implied freedom, but also be effective or reasonably practicable? And finally, the court will ask whether the balance between the purpose of the legislation and the impact on the implied freedom is adequate. And so they'll simply make a value judgment about whether there's an adequate balance between the purpose on the one hand and the impact on the implied freedom on the other. And if the law fails at any of these steps, it will not be regarded as constitutional. This particular approach has not been received with unanimous support by the justices of the High Court. And from the outset in McCloy and in the subsequent case of Brown, and as we'll see in Unions number 2, some judges have dissented from this approach and preferred other approaches. And so I think it would be helpful if there could be a clear and consistent statement from the High Court about how to adjudicate cases involving the implied freedom. But it's unfortunately not forthcoming in Unions number 2. And I'm just going to briefly illustrate why that's the case. So, for instance, the joint judgment of Kiefel-Bell and Keene apply a necessity test but neglect the suitability and balancing stages of the test. Justice Netto applied the structured proportionality test. Justice Gageler applied a test derived from US constitutional law, which is sometimes referred to as a categorical approach. which Justice Gageler has favoured for some time. And essentially what that does is it tailors a standard of review to the particular case before the court and the risk to the implied freedom. Justice Gordon maintained her resistance to structured proportionality. And what I mean by that is Her Honour preferred the test that was used prior to the structured proportionality test, which was simply an appropriate and adapted test. And Justice Edelman may have endorsed structured proportionality, and that there's a remark at one point that's suggestive of that, but ultimately he resolves this case at step two, finding that the purpose of the law was not legitimate. We can't tonight ask the question of whether the structured proportionality approach would be the correct one for the court to adopt. As you can see, it's a matter of controversy. Really, what I wanted to do this evening was just point you to the fact that there is a controversy in relation to this issue, and this case doesn't resolve that controversy. There's also, as far as the structured proportionality test is concerned, you will recall that the second question as part of that test was a question about necessity. And on this point too, there's been some disagreement among members of the court about how this necessity leg of the analysis should be understood. And I'll just point you to one of these points of disagreement. And this is an extract from the joint judgment on the one hand and Justice Nettle's judgment on the other. What the joint judgments say is that when you're looking for an alternative measure that's less burdensome upon the freedom, you have to consider whether that other measure is equally effective. The other account of necessity we find in the case law is articulated by Justice Nettle, and he says when we look to the alternative, it doesn't have to be equally effective or as effective as the challenged measure. It simply needs to be obvious and compelling. And this might seem purely semantic, but actually quite a lot can turn on this, because what the experience of some other jurisdictions seems to suggest is that if you look for measures that are alternatives to the challenged measure and ask whether they're equally effective, it's normally the case that the necessity leg of the proportionality test will be satisfied, because because other measures will seldom be equally effective. And what that does is it means that the necessity leg becomes less meaningful in the proportionality analysis. So my preference is for Justice Nettle's approach, but this is another sort of area of doctrinal controversy that doesn't seem to be resolved by this case. Now, I'm mindful of the fact that I'm running short of time, and so I am going to wrap up, fortunately, on the final issue that I wanted to discuss this evening. And that final issue is this concept of deference, which plays some role in this judgment. And the state of New South Wales, not having much in the way of a justification for this law, really sought refuge in this concept of deference. And what they said was that, if we look at case law from Canada, for example, the courts have recognized that when a law is challenged, sometimes it's appropriate for the court to recognize that it has limited expertise in this area, and so it shouldn't sort of step in and immediately set aside the judgment of the legislature. Unfortunately, though, the state of New South Wales, I think, misconceived this concept, because they effectively presented it as meaning that they were not accountable at all for the change they'd made to the electoral expenditure law. And in essence, what they argued was that the court should simply not scrutinize the reasons for the change. They were beyond the scope of the jurisdiction of the court. That's a misunderstanding of deference, because what deference really requires is just a level of respect for the decisions of the legislature, given that they may exemplify some expertise which the judges don't have to the same extent. Unsurprisingly, therefore, the High Court simply rejected this out of hand and said that the state of New South Wales could not seek refuge in this concept of deference, and they couldn't exempt themselves from accountability. The joint judgment, though, did seem to sort of reject deference as a useful concept altogether and say that it's never applicable. As a thought experiment, though, it's worth comparing this case to a case from the United Kingdom, which is the case of Animal Defenders International in the United Kingdom. And what we saw in Unions number 2 was that you had a change to electoral expenditure law where there had been a process of inquiry, but it was not taken seriously by the lawmakers. And as well as that, it was partisan, which is why we had this case. In Animal Defenders International, in contrast, the British Parliament had introduced a ban on certain forms of political advertising, but that was pursuant to a lengthy process of consultation and inquiry, and the legislation had been enacted on a bipartisan basis. So there's no question about its partisan nature. And in that case, both the House of Lords and the European Court of Human Rights recognized that they should attach some weight to that process of inquiry and the bipartisan support for the legislation. I tend to think that in Australia, even in Australian jurisdiction, a legislature adopted legislation bearing upon electoral expenditure or political advertising that had similar characteristics. It wouldn't be inappropriate for the court to take that into account. But that's not the case that we had before the High Court in Unions number 2. Instead, we had possibly partisan measures that lacked justification and that were disproportionate. And for that reason, the court unanimously found that they were invalid. The High Court did not resolve all the issues about the implied freedom that I've discussed this evening, but there are a number of other cases that will come before, or judgments that are pending, that might go some way towards dealing with those issues. I should add, before wrapping up, I think part of the reason why the court didn't resolve all these doctrinal issues was simply because the justification for the law was so flimsy. And so in the joint judgment, for example, it just didn't warrant a very developed proportionality analysis. The law clearly failed at the step of necessity, and so a sort of rigorous analysis wasn't required. I'm also aware, though, I've kind of moved fairly quickly through some fairly technical doctrinal material, so I'm very open to questions afterwards if anything wasn't clear. I should also, though, a bit of shameless self-promotion. If anyone wants to read further, you can take a look at that in due course, but I'll leave it there.
Thank you. Sorry, I'm just suggesting that we move the projector because I'm aware that it's cutting off some of the audience. And as Murray's pointed out, we do have time for questions. I know that there's a microphone perhaps moving around the room with Ben. Shall we take it, Ben, that you're kicking off with the questions? And then we have one at the back.
Is this? Oh, there we go. It was just more of a comment. I just wonder whether the point about deference that you raised, Murray, is perhaps importantly understood in a context where New South Wales presented basically no evidence as to why they decreased the cap, and maybe the comment by the joint, or in the joint judgment, should be understood as simply making the point that the court wouldn't afford the legislature the level of deference that New South Wales said it should. I don't know the standard of evidence is necessarily going to be particularly high, but certainly the fact that New South Wales put up nothing except the JSCEM report and the expert panel report maybe suggests that they were on a bit of a hiding to nothing, but just a thought.
As I understand it, yes.
Yeah. Thank you, Ben. I mean, I agree entirely that any kind of deference in this case would be utterly inappropriate, and the submissions of the state of New South Wales just misconceived the concept utterly and arguing it exempted them from any kind of scrutiny. So I really just mentioned that because I think there's deference as a concept, as I think you know, it has quite a lot of currency in some other jurisdictions, so the UK, Canada, South Africa, but it's one that is not really discussed in Australia, even though there's been a move towards a structured proportionality test, and the two are sometimes seen as working together.
Yeah.
And the only reason I picked up on it was just to sort of, as a thought experiment, ask whether it would ever be appropriate.
Yeah.
Not that it was appropriate in this case at all. I completely agree with the joint judgment's impatience with that submission. But I thought it just was worth posing the question, if we had a set of facts more like the animal defenders case, whether it would be appropriate, and that might be something we can consider in a later case. Yeah.
Yeah, so I mean, just that it might not be an outright rejection of the concept as a whole, just its application in this case. Just a thought.
I think we have a question up front in the microphone. Do we have one at the back?
Continuing on the difference theme a little bit, Murray, I'll ask you a admittedly very basic question, federalism question. Sort of a prior question that says, I'm pretty sure I know the answer to it, but it's not you can go before me. The High Court's fantasies about implied rights in the Constitution, they apply equal force to the states as they do to the Commonwealth. Is that correct?
Yeah.
And if so, second question, if the answer is yes, as you love, are there any doctrinal criticisms of that?
Yeah. So this question, so just to clarify, the implied freedom is derived from the Commonwealth Constitution, Section 7 and 24, which established the House of Representatives and the Senate. And because of that, there was a question for a long time that arose in the case law and in academic literature about whether this bears upon state law as well as Commonwealth law. And in Unions New South Wales number 1, what the High Court found was that discussions of political matters at state and territory level are so interlocked with federal political issues or Commonwealth political issues, that it's not possible to distinguish between the two. Now, and for that reason, state laws and territory laws are as subject to the implied freedom as Commonwealth laws. Now, that's not without controversy. There's certainly been academic discussion of that, but the current position of the High Court is that they simply are subject to the implied freedom to the same extent as Commonwealth law. And that's why, in this case, that wasn't a live issue. It just wasn't really discussed.
I think we had a question at the front, perhaps, and then Jean. We'll go Jean and maybe at the front.
Well, this is a question for the whole panel, but I wonder whether that the approach taken in this case might not arise so much in other cases in the future if the government is, say, setting out the reason or the justification for a law that burdens the implied freedom when it passes that law in a second reading speech in Parliament, and whether the court might be prevented from actually looking behind what's set out in that second reading speech by reason of parliamentary privilege, and whether there might be some issues, like do you think that might be a limiting factor in the future if the government just sort of says, well, the purpose or the justification for this law is what we set out here. You know, you don't refer to any of the background documents that might go behind what's set out in that speech, and whether there really would be an ability to unpick that.
Yeah, thanks for the question. They did set out very clearly the purpose of the law, so that was up there on one of the earlier slides. So insofar as that, they made that clear. What they didn't make it clear, and this is where is in the eyes of the High Court, exactly why that certain provisions in that legislation sought to impose further limitations on freedom of political communication. Does that make sense? So the legislation itself, there was a purpose listed, but as Murray's talked about proportionality, when you see the scaffolded levels of political caps on expenditure, to arbitrarily change one in relation to all of the others, that part wasn't appropriately explained.
say also that determining the purpose of the law is done through ordinary process of statutory construction. So there'll be a question of statutory interpretation about the circumstances in which the court can look to Hansard and comments made in Parliament. And I'm not offhand familiar with when that's permitted, but I'm sure there are other people here who do know the answer to that. And part of the complicating factor too is that there's a distinction that's drawn between the purpose of the law and the motives of the legislators. So the subjective motive of members of Parliament is not typically what you're looking for, it's the purpose of the law. And that can become quite a difficult distinction in some cases, as we can perhaps see.
I wonder if we had a question, yeah?
I just also have a question about deference, the hot topic for tonight. So just on the comments at the back and deference perhaps not being totally ruled out by this case, when the plurality talk about it, they cite McCloy, which seems to just completely rule out deference, or that was my understanding, which is potentially wrong. So I guess it's twofold. It's one, is that really still open? And secondly, if it's not, why are they sort of so reluctant to pick up this concept, especially when it seems to be partially implied by the test that they're using, at least at the necessity stage, when we've got the obvious and compelling or potentially equally effective, which that it seems like that's what it's doing, but they don't sort of want to step there?
Do you have any thoughts on that?
Oh, probably a bit more in your space, but broadly speaking, the way I read it, they went down the path of using deference because they hadn't done their homework. So there wasn't clear rationale about why these particular provisions were required. And the issue is really around how you go about changing one particular cap and leave all the other caps intact. Because you're halving, in effect, what third-party campaigners can actually do. And that does have a material bearing on them in relation to other campaigners. So even if we accept that political parties are privileged, you know, how much privilege are we according one political actor in relation to other actors? So that was the part where they fell down, and it seems to me, and this is probably more Murray's space, but they're using the deference argument because they weren't able to do the option A.
On the deference question, I mean, it is an interesting question. And you're right that in McCloy, and I think in this judgment too, the statements about this concept of deference are fairly categorical. But strictly speaking, they're arbiter, I think, because as Ben pointed out, really on the facts of the case, the issue wasn't really raised. I mean, part of the issue, I think, is sometimes courts don't like the word. So in the animal defenders case, Lord Bingham doesn't talk about deference, he talks about giving weight to the decisions of Parliament. Secondly, I think there's been more debate about the judicial role in respect of structured proportionality in jurisdictions where you've seen the adoption of a Bill of Rights, because it raises that question more prominently, whereas the structured proportionality test is really only employed in relation to the implied freedom. So I think what we may see is, you know, despite these rather sort of categorical statements saying it has no role, we may see a case later on with a different set of facts where implicitly there is a degree of deference being employed to sort of acknowledge areas where a court may not be the best decision maker, but it may not employ that language. But as you say, there's so many aspects of the proportionality test that might seem to require it in some circumstances that even though we have these remarks that seem quite categorical, I wouldn't rule it out entirely in a different set of facts.
I'm conscious of the time, but I think we have one final question, if everyone's content.
Just following on from what Martin was saying before, it seemed to imply that if everybody's expenditure had been cut in half, then things would have been okay, potentially, because nobody was being discriminated against, if you like. So does that mean, therefore, that whenever parliaments come up with this proportionalities, the original proportionality is always okay, and therefore one can't deviate from the original proportionality. And secondly, following on from that, some states, as you know, don't have any caps at the moment. So if they then introduce them, do they have to follow the precedent of the other states? Have all the other states got the same sort of proportionality, or can Victoria have a much different proportionality from New South Wales, but once they did it first, then that's fine, and you change it, then you're in trouble? So if WA decides to go down the route of capping expenditure, whose proportions do we follow?
It's a very interesting question. I don't think what the court's saying is that you can't change the relationship between the different actors, but you have to justify it. There's more than one politician who's justified backflips by saying, I change my mind as the circumstances change. If the circumstances change, that might mean that, say, third-party campaigners are seen as having certain undue influence over the electoral process, then that could be positioned as justifying a need or a change in the legislation. So I don't think the proportionality as set out in New South Wales obliges other jurisdictions to mirror that, or even that in New South Wales you have to retain exactly that proportion. But you have to make it very, very clear what circumstances have arisen which justify such a change. And the expert panel asked them to do this, and they never did it. So that's why, at least one of the failings that they made.
But do you need to justify the original one? So if Western Australia introduces legislation, you could imagine a ridiculous situation where we have very, very tight restrictions on third parties, but unlimited spending by parties, or vice versa. I mean, and I wouldn't have thought legislation would be the place to actually justify that. I guess it has to be in a second reading speech. But a very subjective matter of how you justify the different amounts.
Yeah, I think the proportionality test doesn't rule out different approaches in different jurisdictions. What it requires is the state to justify the scheme of legislation that it's introduced. But as you say, there are different approaches that can meet that test. What needs to be required is some sort of justification, and then show that the legislation is tailored to that justification. But it doesn't mean that as a result of that, there's one proportionate approach that would apply in every jurisdiction. It just means that this test of justification needs to be met.
I know I said there was one question, but there's one more at the back again.
Good evening. My question is, what's the definition in the legislation on donation? And the second thing is what's the categorisation? Because it's obviously dollar value, but if you get 1,000 people out there campaigning for you, does that come into the level of donation? And the other thing is, if you're personally wealthy and you can afford to pay for your own campaign, does that restrict your expenditure as well?
Yeah, Kobe's very helpfully provided some of the detail from the case law that demonstrates what they meant by electoral communication expenditure, defined in the Act as expenditure on advertisements, production and distribution of election material, the internet and telecommunications. So it doesn't cover volunteer activity and organiser activity. Hope that helps answer.
I know the question was much bigger. I wonder if now is the time, though, unless Murray...
I don't know the answer to the second part of the question, which is why I didn't offer a response. I suppose we've looked this evening at caps on third-party expenditure. I'm not sure, though, about if you have a wealthy individual, in politics, what limits might apply on the extent to which they can use their personal wealth.
So the person who's not affiliated is classified as the third-party campaigner. If they register under the Act, they have a higher limit. If they don't register, they have a lower limit. So the unregistered amount is $525,000. So if some wealthy individual wants to spend $525,000 influencing the New South Wales election, they can. But if they do more, they'll breach the Act. Just one more point, though, on the question that you asked. I think you have touched on this problem with trying to regulate third-party campaigners, because when you're trying to understand exactly how much money third-party campaigners are spending on an election, it's much more difficult. For a political party, their entire mission is to win votes, to manipulate public opinion, to engage in political activity. But if you're a third party, if you send someone to Canberra to lobby on behalf of your organisation to change an act, is that political campaigning? You know, there's a lot of grey areas around third-party campaigning which are much more difficult to resolve.
I think on that note, we may extend our thanks again to Martin